Weldon's ready to go.
Morning, Your Honors. May it please this court. The City of San Marcos requires private property owners to get permission from a board of bureaucrats before they make any aesthetic change to the front of their home. The Moneys believe that this ordinance is unconstitutional. But the question before this court today is not whether or not the ordinance ultimately passes constitutional muster, but whether or not the Moneys bring the kind of constitutional challenge that can ever see the inside of a federal courtroom. The reason for this is because the district court not only held that the Moneys' claims were not ripe, but also reached out as a matter of law to hold that neither the United States nor the Texas constitutions have anything to say about these sorts of aesthetic zoning ordinances. In doing so, the court ensured that the Moneys will never be able to bring these claims again, regardless how many times they return to the city to ask permission to exercise their property rights. That judgment not only ignores the Supreme Court's most recent guidance on the issue of ripeness, but also disregards 50 years of federal takings precedent and more than a century of Texas precedent on the scope of the municipal police power. We would ask that that judgment be reversed and that my clients finally have the opportunity to present their claims on the merits below. Now, there are three major issues in this case: ripeness, then with regard to the merits of the federal claims and the state claims. I'd like to start today with the issue of ripeness. Now, at the outset, it's important to note that Article 3 ripeness is not at issue in this case. There is no dispute that the ordinance applies on its face to the Moneys' property and that the city has applied the ordinance to restrict the Moneys' property rights. Instead, the city raises issues of prudential ripeness, which would be a 12b6 motion to dismiss. Now, they really raise two issues on this front. First, the city claims that the Moneys did not receive a final decision under Williamson County because they did not file an administrative appeal with the zoning board.
But there's more than that, but maybe it's not been sufficiently argued. You didn't, the claim about the KKK connection of this balcony or this emblem on the balcony was not presented to the commission, if that's the name of the administrative body. And they may well reach a different decision if this other evidence was presented to them. So what your constitutional claim has nothing to do with that. But insofar as whether any court would ever need to get to the constitutional claim, she may receive the relief she wants, which is the removal of however much of the balcony that she wants to remove, just by raising the claim for the first time with the commission.
Your Honor, 2 points on that. There's a reason that the city did not raise this claim in its motion to dismiss or in response to our motion for summary judgment, because it's simply wrong on the facts and it's wrong on the law. First, with regard to the facts, there is no dispute that the Moneys made clear to the city that the balcony was contrary to their family's values. Ms. Money did that in her application, even though the ordinance doesn't require it, and she did it at the hearing, even though she wasn't represented by counsel.
Are you saying it's enough just generically to say it's inconsistent with my values? Or are you saying that this issue of the KKK connection was actually mentioned?
I think it's both, Your Honor. First, if you listen to the discussion, when she said it's contrary to her family's values, there was no follow-up question. And if you think about it, that would be a weird thing to say: a balcony is contrary to my family values, and there would be no follow-up question.
Well, it depends on who's on the board and what to make of that, but make the argument you want to make.
Yes, Your Honor, but it's because everyone in that room knew, and the city's never disputed the fact that the commission members knew who Mr. Zimmerman was and why it was contrary to her family values, and that's because they were required under the ordinance to have prior meetings before this final hearing where Ms. Money talks to them.
Sounds like you're telling me some things that are not in evidence. Is that a fair statement?
Your Honor, I think that's fair, except that in the hearing she discussed this, that she had had prior meetings with the city staff beforehand. But also, I think, to your point, if there were any factual dispute on this issue, that's something that should have been decided on summary judgment or on trial after discovery. This should not be something that is raised on a 12b6 motion, particularly when the city didn't even raise it in its motion to dismiss. So if there's any sort of factual dispute about what was in front of the board, that's not appropriate for it to be decided on a 12b6.
Well, it does seem to me that if, in fact, most of what you said so far is not part of the record, if, in fact, this issue of the KKK connection not having been presented to the board in a meaningful way, commission in a meaningful way, was not an argument made by San Marcos in front of the district judge that has some purchase.
Your Honor, I would take a look at their motion to dismiss, and you will find it nowhere mentioned in their motion to dismiss. It's raised after the fact, in fact, it's nowhere in their response to our motion for summary judgment. It's only the third round of briefing after the district court herself starts talking about it that you see this appear in their briefing. Now, the second reason that I don't think that it's relevant is it misunderstands Williamson County as a matter of law. Williamson County is not an exhaustion doctrine. It is a finality doctrine, and it only requires that the city have an opportunity to say how the ordinance applies. And here the city has said how the ordinance applies. The monies can't remove the Z, period. Repeatedly, the city has made clear in ROA 372 that it is, quote, wholly irrelevant, unquote, under the ordinance what the commission knew about Mr. Zimmerman's clan ties. If it's wholly irrelevant under the ordinance, it is wholly irrelevant to Williamson County because Williamson County is not an exhaustion doctrine. Now,
does it make a difference if the constitutional claim is a regulatory taking versus a per se taking?
I think Williamson County was originally designed for the sort of ad hoc Penn Central takings where you're talking about how much of the property can you still use. And a lot of these cases that come out of the early Williamson County cases are based on it being unclear under the ordinance what you can do on the property. Here, there's no dispute how the ordinance works here. If my clients want to make any aesthetic change to the front of their home.
So you're alleging a per se taking.
That's right, Your Honor. We are alleging a per se taking under Loretto. Now, the actual argument that was raised in the city's motion to dismiss was one of administrative exhaustion. It wasn't even about not exhausting remedies before the commission. It was that we did not file an administrative appeal with the board. Now, the Supreme Court was clear in Pactel that property owners do not have to file administrative appeals with the board. They simply need a decision from the initial decision maker, which is what we received in this case. Now, it's also important to note that even with regard to any administrative exhaustion, that would not apply to our facial claims. And no one, neither the district court nor the city, has ever addressed how our facial claims aren't ripe in this case. But even as to the as-applied claims, Pactel is controlling. In fact, even before Pactel was decided, under Williamson County, we would not have been required to file an administrative appeal. Because in Williamson County, the Supreme Court made clear that property owners do not have to file administrative appeals when the administrative body only exercises appellate review and not independent judgment. And if you look at the ordinance, that's exactly what the board exercises in this case. If you look at 2.5.5C of the ordinance, and that's at ROA 229, the ordinance makes clear that the board only exercises substantial evidence appellate review and, quote, may not substitute its judgment for that of the commission, unquote. So even under Williamson County, we would not have been required to exhaust those administrative remedies, certainly not under Pactel. The second exhaustion argument that the city raises goes to the state claims. The city argues that even if we don't have to exhaust our federal claims, we do have to exhaust our state law claims. The problem with that is, as we pointed out in the brief and in our 28J letter that we filed last week with the court, Texas courts have recently and repeatedly held that administrative exhaustion is not required for constitutional claims seeking solely declaratory and injunctive relief. And that's exactly what we raise under the state constitution. Our Article 1, Section 19 claims, they're not takings claims. They don't seek any compensation. And if you look at all of the cases the city cites, every case the city cites is a takings claim or another claim for statutory damages and monetary relief. That is not what our state law claims are. Moving to the merits, starting with the federal takings claim. And I would remind this court that even if the court believed that this case was not ripe, you would have to do something about the district court's merits judgment, because that would be res judicata if we went back down and even tried to ripen our claims before the board. We would have to come back to court, and then we'd be res judicata barred from bringing these claims again. Now, starting with the federal takings claims, this is a straightforward Loretto case. It's difficult to imagine a more straightforward Loretto case. In Loretto, it was a pre-existing cable box that was there before purchase that the law forbid the property owner from removing from her apartment. Here you have a metal Z approximately the same size as the cable box bolted to the front of a home. The standard is the same. It's a physical occupation, and the law prevents my clients from removing it. That's a Loretto taking. Now, the city raises several arguments. I'd like to address two very briefly. First, the city claims that this is not a per se taking it's a use restriction. But that same argument was raised in Loretto and Cedar Point and Horn and rejected in all of those cases. It should be rejected here. More importantly, it's contrary to the text of the ordinance itself. If you look at ROA 238, the ordinance is clear at 238 that the guidelines have, quote, no control on the use of the building, unquote. This is not a use restriction, it's a mandatory physical occupation, and that's a taking. The second argument that they raise is that the Z was already on the home when my clients purchased it, but the cable box in Loretto was already on the property when that property owner purchased it. It wasn't installed by the government, it was installed by a previous owner in Loretto as well. That's not a basis for the distinction. It's certainly not the type of distinction that would be sufficient to sua sponte dismiss a Loretto claim. Moving to the state law claims, there are really three issues on state law where the district court erred that I think are important to note. First, the district court held that cases like Spann and Lombardo had been overturned. Those are the cases dealing with aesthetic zoning in Texas. The problem is the district court did not cite a single Texas case for that proposition. And that's because Texas courts continue to cite Spann and Lombardo to this day. In fact, your colleague on this court, Judge Willett, whenever he was on the Texas Supreme Court, he cited Spann as controlling in his opinions. They remain good law in Texas. A federal district court exercising supplemental jurisdiction did not have authority to disregard Texas Supreme Court precedent simply because it was old. In fact, if there was any dispute, and we don't think there's any dispute as to whether or not it's good law, but if there were any dispute, this court would have to certify that question to the Texas Supreme Court. It would not simply hold that a case is no longer good law simply because it's old. The second error that the district court made with regard to the Texas claims is that it held as a matter of law that the ordinance, both on its face and as applied, is based on preserving historic structures and not aesthetics. But the problem with this argument is it disregards the operative text of the ordinance and the city's official findings in this case. In fact, if you go back and look at the district court's opinion and all of the city's briefing in this case, both here and below, they never once cite the operative provisions of the ordinance that we challenged or the city's official findings in this case. Because when you look at the ordinance itself, while the ordinance speaks elsewhere about historic character, when the ordinance says how you define historic character, it has 10 criteria. And each one of those are about the rhythm and spacing of solids, the visual compatibility of the home, the texture of the brick, and all of these things apply to homes whether they are historic or not. They apply to empty lots. They apply to homes built in the 80s. They apply to a home that's built in 2017 right down the street from my client's home. These are aesthetic-based restrictions. But if there were any doubt on this, if you look at the city's official findings in this case, and you look at, let me see, and that's going to be at ROA 199. The official findings in this case were that removal of the Z would have no historic impact, no historic effect. Not some, not a little bit, but none. And the city has never explained how this is a historic preservation ordinance, or as applied in this case, when its own official findings in this case were there'd be no effect on the historic character of the neighborhood by removing the Z.
Is it clear, though a change, I guess, that the only desire by your client is to remove the Z and not the whole balcony?
My clients, the Z is integrated to the balcony itself. The balcony itself is about this big, and it's bolted on with bolts. So that was the request that was put in the application.
What was the request?
To remove the Juliet balcony. It's all one integrated piece. It just comes off with...
So remove the Z means to remove at least the railing, but the whole balcony probably.
Yes. Now, it's not a functional balcony. It is a decorative balcony. There's no dispute in the record that it has no structural reason for being there. There's no way to exit the window to that balcony. The city, if you look in the record, says that it would not damage the facade of the home in any way. It is literally a metal grate, just like the cable box in Loretto. It is literally...
Not where Zimmerman stood and proclaimed his views in years past? That's not
no
significance of the balcony?
No, Your Honor. There's no historic significance to the balcony whatsoever, and we know this because the city's official findings in the case at ROA 199 is that removal of the balcony would have no historic impact. So the city can't now claim that it's based on historic reasons. One more point with my last 15 seconds. The last error from the district court on the state law claims is the court just didn't consider proportionality, which is required under Article 1, Section 19, rational basis claims in Texas. That is part of the rational basis test. It's not a separate claim. That's built into any rational basis claim, and the court did not consider that. That alone is error. So thank you, and I'll be back for rebuttal. Thank you, Your Honors.
May it please the court. My name is Joanna Salinas. I'm here representing the city of San Marcos in this matter. State and federal law, statutory and common law have recognized that preservation of areas of historical and cultural significance is an important act of a government entity. Ordinary, permissive, valid exercise of government power. Penn Central in 1978, which has been nearly 50 years ago now, commented at that time that over the past 50 years, previous to that, over 50 states, 500 municipalities had enacted laws to require or encourage the preservation of areas of historic or aesthetic significance. Federal, state, local laws all have codified that concept. Texas has expressly recognized that in its state law. The local government code expressly recognizes that it is a valid exercise of government power to protect and preserve places and areas of historical, cultural, or architectural importance and significance.
What is the factor or factors that the city would consider in declaring something to be of historical significance?
So the city goes through a process of deciding what areas are going to be declared an area of significance, and it has an entire process. It then has recommendations and reports. It then goes into a public hearing in front of city council, and they vote on that designation.
But what are the factors that they consider? In other words, is it a building that is over X years old or constructed in a certain way, like the French Quarter, that gives character to it, that uses certain type of building materials that are no longer available? What would make something historical as opposed to just a really nice building that was built 2 years ago?
Right, so in this case, we're not talking about a specific building that's been designated. We're talking about an area. And so under those circumstances, they're looking at the neighborhood as a whole to see what it shows that is significant to a specific time. And if you actually look in the ordinance, it actually even talks about some areas, neighborhoods where houses were all spaced a certain away from the front of the street, where windows were shaped in a certain way because of the way air conditioning worked, certain types of materials, certain ways porches were designed during a specific time. And so it's particular to the area. Now, there's no dispute in this case, and frankly, no one is complaining that it was improper to designate this area as historically significant. That's not part of the challenge in this case. That was done 20 years ago, and no one has challenged that the neighborhood in which the appellants purchased this home was already designated, and that was a legitimate designation. The San Marcos, when they've gone in and done that, then has set up this historical commission that then reviews any changes that someone wants to make in those areas. And appellants knew when they purchased their property that they were purchasing their property in an area that had received that designation, and that designation would require them to go through steps if they were going to change what people saw when they came through the neighborhood.
Let me ask, and this may put to rest the idea of when the disclosure was made about the specific reason that the plaintiffs wanted to make this change. And that, by that I mean the association of the letter Z with a person that is Klan affiliated, which they find offensive. If the city was aware of it at the initial level, the initial presentation, if they were aware of that, would that have made a difference?
I don't know. Because
But can't you, I mean, we're here in a federal circuit court over a case that could be settled if the city would just say, oh, we didn't know that this was the problem. Now we see, and we kind of agree with you, we would not want to live in a Klan-affiliated home either. But that conversation apparently has never taken place. So we're going to battle it out over something that, like ships passing in the night.
And the reason it hasn't is because that isn't a city administrator decision, right? It has to go back in front of the commission and whoever those commissioners are when they're there. One of the aspects that the commission is given as what they're supposed to be considering when they look at whether a certificate of appropriateness should be granted is its cultural significance, historical significance, but also hardship to the owner. And so until the owner presents what that hardship is that they're identifying, then I don't know how the commission's going to rule. They could have said, is there something we can do that's in between? I think going back to this question of, is it this Juliet balcony or is it the K, is it the Z? Well, the only thing that was applied for was to remove the balcony. And when you read the discussion, that's what the discussion is about, is, well, here's what the balcony is, here's what the balcony does, here's what we think it's from. And so there was no discussion about, well, is there a lesser alternative here that's available? But that's not a decision.
What you're talking to Judge Engelhardt about is something at least opposing counsel said was not raised until very late in the day by the city, that you did not argue at the motion to dismiss stage and earlier that plaintiffs should have informed the commission, if that's the name of the initial body, of this Klan connection. What do you say to that?
Our briefing does include that before we got to you, but I do agree that we did not raise that in our very initial filing.
In district court?
In district court, although in district court it was raised. It just was not raised in our initial motion to dismiss. But in our briefing in support of the magistrate's finding, that was discussed before the district court issued the order that we're here about today.
Let's say we agree, hypothetical, let's say we agree with opposing counsel on how this claim should be considered, that having first presented it, they don't have to exhaust it, they can bring the constitutional claim in federal court, hypothetical. Do you have any case law that would say a failure to present the claim fully in the initial administrative matter affects whether they can come into federal court?
I do not, Your Honor.
Constitutional claim?
We have looked, we have not found any case that said either way, right? That said that you do or you don't. But I do think that when you look at the rationale, I mean, there is a reason that all of the cases recognize that before we come to you, before we're taking the court's time, that the government entity have a chance to make a decision, and for it to make that decision to actually say you can go in front of the board or the individual and ask for something and not provide them this underlying reason, and then come before the court and use that reason as part of why you're presenting your case, seems like it makes a farce of the initial requirement. And so while I will acknowledge that I do not have any case law, it does not seem like it is a genuine effort to get a final decision, right? Finality is still required. It may not be wholly exhaustion, but finality is still what Pactel talks about. How are you getting a final decision from the government about a specific question if you're not presenting them the facts, especially those same facts that you make the highlight of the case that you present in court?
Sounds like it would be a vain and useless thing, though, at this point, from your answer to my question. It sounds like city, it doesn't matter to the city. They're here now.
Well, it's not so much that it doesn't matter to the city as much as the city wasn't asked. And the city, the commission...
They've been asked now, and you're here in New Orleans and not in San Marcos. So
Right.
You know what the answer is. Your client has instructed you to defend this appeal here, rather than say, oh, well, we didn't realize and we'd like to reconsider. And I'm not forgiving on the plaintiff's side that they could have been more specific, but we're here now, and there are three of us sitting here, and you're here, and so we're going to decide the case. But I think the answer is that it would have been a vain and useless thing at this point for the plaintiffs to have included any more specificity.
I can assure the court that I do not believe that is accurate. Not that they necessarily would have made a different decision, but they would have had a discussion about it. And I do think that there could have been lesser alternatives that could have been discussed if this had been the reason that they really are there, right? Would just putting a piece of paper over the Z have solved everything? Would we not be here today, counsel, if that's all it had taken? If we just covered the Z, are we done? I didn't get that sense from the pleading, and I haven't gotten that sense from the briefing.
Well, counsel, we're both of you, but without pressing you, gotten kind of outside the record, opposing counsel on the commission really knew all of this and knew about the connection to the Klan. Now you're suggesting some other things. Why don't we get back to the case? I guess we have pushed you a little bit aside. What else you got for us?
Your Honor, I think on the merits, I think that's the other, kind of getting past the ripeness issue. I think there are two fundamental problems with what counsel is asking of this court and asked of the district court. The first issue is that what they have pled in this case under the federal law is only a taking of like physical occupation. They have not pled and are not alleging that this statute is a regulatory taking. Their claim is that it's a per se physical occupation, and that is just wrong. Every case that has dealt with a physical occupation has to do with the government actually putting something there, having a statute that made something go there, not something that was originally with the home, that was on the property when the homeowners got there, and that they're just not being allowed to alter. Altering your property is part of your standard regulatory taking discussion. Whether or not you can change something is part of a regulatory taking. It is not a physical occupation. Otherwise, every case that asks for a demolition permit would be a physical occupation if the demo permit was declined. This statute isn't just about putting something on someone's property. It is about making alterations, whether you want to add something or subtract something. If you're going to do that, then you need to ask for authorization pursuant to the statute. Even in Penn Central, which was clearly a regulatory taking case, that case actually involved two alternatives that the owner had brought forward. They had asked for either the right to a demolition permit or for an addition, and both were rejected. And in Penn Central, both were assessed using regulatory taking and not physical occupation. This is not a physical occupation case. As a result, the district court was correct when it dismissed the claim on those grounds. On the state law side, the allegation seems to be that Texas doesn't permit this type of regulation. But the Texas Local Government Code expressly recognizes that this is within the police power of City of San Marcos. 211.001 says, one of the purposes of zoning is protecting and preserving places and areas of historical, cultural, or architectural importance. That statute goes on to say that that includes, specifically for historical areas, the ability to restrict the alteration or construction of property in that area. This is consistent, so the statute that the city has is consistent with what the local government code says they are able to do. What the actual statute says is not about pure aesthetics. Now, aesthetics is not a legal term, and so I think it gets kind of used in a couple of different ways in the cases and in the commentary. When used by counsel and in some of the law reviews he cites, they're talking about sort of the concept of beauty, the concept of whether you like what you see. And that's a very different concept than we are regulating what you see. That we are saying that this area, the way this looks, the way the fences fit together, the way that things are distanced from the front. We're not talking about it's an area that we like more, that the city favors. It's because that's how they were doing things in the 30s. Or because in the 50s, when they just started getting AC, people started building their houses differently. And in the statute, it actually talks about those reasons. It doesn't just say we like this pattern better. It notes the difference between different neighborhoods, that in this neighborhood, it was common to be building it this way. In this neighborhood, it was common for the fronts of the houses to look this certain way. In this time, they were more likely to have porches because they didn't have AC. And so the porch was an important thing, and that's something that would be important when they were looking at that neighborhood. But in other neighborhoods, that isn't an important distinction. And so the use of the term aesthetics as if it's some word that is automatically negative, I think is a disservice. In this case, yes, we are looking visually, because they're in an area where this is a district that's being protected, and we aren't trying to interfere with the homeowner's use of their property beyond what is part of that visual look, which has been approved, was approved, and isn't being challenged.
Do you accept that the law of Texas on whether zoning purely for aesthetics reason is permissible, that the law in Texas on that is likely different than federal law?
I don't think so. I honestly think that part of
You
it's
think
the
these
word.
100-year-old cases that our good friend Don Willett still cites for good or ill, rightly or wrongly, are not really the law?
No, because when you actually look at those cases, they are not talking about aesthetics the way it is used in Penn Central, right? They are talking about aesthetics about the idea of how something looks and whether you like it or not. And so even the Fordham Law Review article that's cited, if you actually pull that article and look at it, what it is talking about is beauty. It's talking about regulating junkyards. It's talking about billboard signs. It's not talking about just how it looks. It's about making decisions about what we think looks better. Having architectural boards that say you can't have too many houses near each other that look the same. So those are about kind of a judgment about what looks good. And when you look the definition of aesthetics up, what you find is a couple of definitions. And so the idea of aesthetics is beauty, I like it, I think it's pretty, versus the concept of aesthetics of having a certain look. And in this case, the idea of, if you look at the Fordham article, it never mentions the concept of like a historic district where you're trying to get a specific look, right? Where the look matters, where all these houses were built of the same stone. That's visual. There's nothing about any cases that have come out in Texas that says we're not in favor of that. And when you look at, they say, that Texas Supreme Court case that talked about the city of Houston, right, where the city of Houston came up with this historical preservation ordinance, and they were fighting over whether or not that was appropriate because, you know, Houston doesn't allow zoning. In that case, when you read what the historical preservation statute was, there's no issue about that. As a matter of fact, aesthetics shows up in that case, I think, 100 times, right? It's in there, but they're talking about it from the sense of historical preservation or cultural preservation or a certain architectural look, and not the idea of beauty, which is, I think, what you read when you actually sort of look at the earlier cases about we don't want the government making personal judgments about how your house looks. But when we get into this world of zoning where we've decided that this is an area that we want to preserve, that has a value, and that's not being challenged here. No one is challenging that they live in a district where there is something that we are trying to preserve. When we talk about aesthetics from that position, I don't believe that there's any case law where Texas has come in and said, no, we're not protecting that. And the local government code expressly protects that. As a result, we are asking the court to uphold the district court's finding.
All right, Counsel.
Thank you.
Thanks again, Your Honors. First, the city could have designated this property a historic structure. It did not do so.
Well, it's an historic district. Is that a distinction that matters?
I think that it does matter here because a historic district, they've just created a backdoor way to do aesthetic zoning when you look at the way this ordinance is structured. This historic district includes vacant lots, which clearly aren't protecting historic structures. It includes homes built in 2017, and there's nothing in the ordinance that requires it to be a historic structure. The city could have designated it as a historic structure. It didn't, because there would have been tax benefits and other benefits associated for my client if they would have designated it. It could have condemned a historic easement under the text of its own ordinance. And it could have applied the exact same regulations here by condemning a historic easement on the front of the property. It didn't do so because, again, it would have had to pay for it.
If we agree with you in part at least, that it should not have been dismissed, motion to dismiss, how much of what you're telling us do we really need to decide about the issue of aesthetics?
Well, I think that I would recommend that this court take a look at SPAN itself. SPAN itself talked about...
No, but what we would say is the district court improperly granted in part on the issue of exhaustion or whatever label you want to use for that.
Right.
There was the additional findings about the actual claim. So it would not just be enough to rule on the basis of there was no need for them to go further in the administrative process?
Your Honor, I think that with regard, if you think that the case is ripe and you think that it was wrong under PACTA, which we believe it is, with regard to the Texas claims, it would be easy enough to say that it appears that Span and Lombardo are still good law in Texas. And here, we don't have to reach the outer bounds of aesthetic versus historic because the city's official findings, in this case at ROA 199, was there would be no historic impact. So all that's left is aesthetics. And SPAN defines aesthetics. If you're looking at architectural symmetry, if you're looking at uniformity of buildings, those are the terms from SPAN. Those are aesthetic restrictions, and those are unconstitutional under Texas law because the Texas police power over property is largely limited to nuisance abatement and policing harms. Now, the city pointed to the Texas Zoning Enabling Act. 2 points on that. First, I would look at, yes, it does say you can preserve historic structures. This is not a historic structure. But two, if you look at 211.004, it limits the ways that you can protect historic structures. Crowding, fire, flooding, the types of things that are codifications of the SPAN test. She pointed to the Powell case. The Texas Attorney General in Powell argued that aesthetic zoning was unconstitutional because they were amicus in that case. The Texas Supreme Court explicitly did not reach that question because the plaintiffs refused to raise it. But there was a concurrence in that case from 4 justices of the Texas Supreme Court that said historic zoning is still subject to the Texas Constitution, and the case it cited was SPAN. SPAN remains good law in Texas. With regard to the federal takings claims...
What does SPAN mean?
What was SPAN?
What does SPAN mean?
SPAN just means that the police power, the zoning power, is based in the old maxim sicu terri, right? It's that you don't use your property in ways that harms others. You can't put a dynamite factory next to a school, but the city doesn't get to tell you what color you paint your shutters. That's SPAN. That's the scope of the police power in Texas. And it always has been. And to the extent there's any dispute about that, the district court had no authority to simply claim that a Texas Supreme Court case, which is directly on point, is no longer applicable simply because it's old. The city has not pointed to a single Texas case.
Well, cited maybe in her brief or in the district court I can't remember was Texas jurisprudence, which I recall as an encyclopedia that doesn't note the possibility that SPAN's still around.
The Texas jurisprudence in that article cites Berman versus Parker, which was a concurring opinion from the United States Supreme Court interpreting the 14th Amendment. Texas jurisprudence does not overturn basically what's the equivalent of a law review encyclopedia.
But is it, I mean, I recall a volume of Texas jurisprudence from Texas State. Is that the Encyclopedia of Texas Law?
It is an encyclopedia, Your Honor. And if you look at the actual, the thing that the district court cited, it's talking about Berman versus Parker, which is a federal case interpreting the 14th Amendment, not the Texas Constitution. I mean, SPAN is cited all the time. I would just close with this, Your Honor. I see that I have 5 seconds.
You can close with this. Go ahead.
Yeah.
Don't worry about the seconds.
Okay, I'm sorry, Your Honor. The reality on the ground today is that if this district court opinion stands, my clients have to keep the initial of a Klansman bolted to the front of the home where they raised their 5 kids. The city has not pointed to anything in its ordinance that would allow a different outcome. If that's not enough to get you into federal court, it's difficult to imagine what would be. I thank you, Your Honors.
All right, counsel. Thanks to you, counsel for the city, for bringing this case to us to help us understand